On June 3, 2025, in the Pyhäjoki District Court in Finland, the trial of Seaman Ekpa continued with the cross-examination of a key prosecution witness, who was formerly Simon Ekpa's financial officer at his company. The witness alleged that Simon Ekpa ordered arms and ammunition from the dark web and sent them to southeastern Nigeria, supposedly fueling insecurity. However, under cross-examination, the witness admitted he himself also purchased a mystery box from the dark web, which included bullets, and he did not have a firearms license or report it to Finnish police. Simon Ekpa's lawyer used this revelation to discredit the witness' credibility, arguing that he had committed criminal offenses himself and should not be considered a trustworthy witness. The judge agreed with Simon Ekpa's lawyer that cross-examination must proceed, and even ordered the witness to report to the nearest police station after testifying, suggesting legal consequences for the witness' own actions. The prosecution then attempted to introduce a fourth witness, but Simon Ekpa's lawyer successfully objected and requested that his own first witness be heard next. Simon Ekpa's first witness is a member of the Biafra Republic government in exile, and also a US citizen, introduced as a close friend and strong character reference. Simon Ekpa's first witness testified that Simon Ekpa is a peace-loving man who received a Peace Ambassador Award in Helsinki in 2023 and has a philanthropic record, describing him as a respected political figure and law-abiding citizen in Finland. The prosecuting lawyer aggressively cross-examined Simon Ekpa's first witness, trying to link Biafra Republic government in exile fundraising activities to arms procurement. But Simon Ekpa's first witness remained composed, rebutting the allegations and demanding clarity in questioning. The courtroom saw rising tension as the prosecuting lawyer became frustrated by Simon Ekpa's first witness' confident and well-prepared responses, which undermined the prosecution's strategy and exposed inconsistencies in their claims. Simon Ekpa's lawyer closed the session by reinforcing that the prosecuting lawyer lacked clear evidence and was attempting to intimidate witnesses rather than present solid facts, while Simon Ekpa's first witness criticized the vague and accusatory nature of the prosecution's questions. On the 3rd day of June in the year 2025, in a quiet courtroom located in the town of Pyhäjoki in Finland, a trial that had drawn the attention of the international community took a dramatic and unexpected turn. The proceedings were centered on a man who has stirred strong opinions both within and beyond the borders of Nigeria. His name is Simon Ekpa, and he is being tried in connection with alleged international crimes relating to arms procurement, insurgency funding, and activities linked to the self-proclaimed Biafra Republic government in exile. This trial has become a major topic of conversation, not just because of the charges, but because of the global voices and surprising testimonies that continue to emerge in the courtroom. One such surprising moment came when an American citizen, described in court as a close associate of Simon Ekpa and also a member of the Biafra Republic government in exile, walked confidently to the witness stand and proceeded to give a testimony that rattled the walls of that courtroom and sent ripples across both Finland and Nigeria. That day started with a continuation of the cross-examination of a man who was once very close to Simon Ekpa. This man was introduced in court as the former financial officer of a company once managed by Simon Ekpa. His demeanor was cautious but determined. He was brought in by the prosecution, and his testimony had been expected to strike a heavy blow against Simon Ekpa's defense. He claimed, with a voice that trembled slightly under the weight of its implications, that Simon Ekpa had been involved in ordering arms and ammunition through the dark web, and that these weapons were allegedly sent to southeastern Nigeria, a region plagued in recent years by violence, uncertainty, and political tensions surrounding the Biafran cause. But the courtroom was not prepared for what came next. As the cross-examination by Simon Ekpa's lawyer began, the air in the courtroom grew heavy. Simon Ekpa's lawyer, known for his calm but piercing style of questioning, began by gently probing the financial officer's own dealings. What followed revealed a crack in the story that the prosecution had not anticipated. The former financial officer, under oath and before the gaze of the judge, jury, lawyers, and audience, admitted that he himself had also purchased a mystery box from the dark web. Inside this box, he said, were bullets. He further admitted that he did not possess a firearms license in Finland and never reported the purchase to the Finnish police. There was a moment of collective silence as these words were spoken, followed by murmurs of surprise and confusion across the courtroom. Simon Ekpa's lawyer paused, allowing the weight of that admission to settle. Then, with deliberate clarity, he argued that a man who had himself committed an offense involving illegal arms purchase and who failed to report it to the authorities should not be regarded as a credible witness against Simon Ekpa. He asked how the court could rely on the word of a man who had walked the same line of illegality that he accused Simon Ekpa of walking. The judge listened intently, brows furrowed, then made a statement that made the room stir again. The judge agreed with the argument raised by Simon Ekpa's defense. Not only did the judge insist that the cross-examination must continue, but he also went a step further by ordering the witness to report himself to the nearest police station after giving his testimony. That order, quiet but firm, carried the weight of potential legal consequences and shifted the courtroom dynamic completely. The prosecution, now facing a setback, attempted to bring in another witness, described in their documents as a fourth witness in the case. But Simon Ekpa's lawyer objected strongly. He argued that the defense had the right to bring in its own witnesses at this stage, especially given the fragile credibility of the prosecution's witnesses so far. The judge considered the objection and ruled in favor of Simon Ekpa's legal team, allowing the defense to proceed with its first witness. At that moment, all eyes turned toward the door as a new figure walked into the room. This individual was described as both a personal friend of Simon Ekpa and a member of the Biafra Republic government in exile. More notably, he was an American citizen. His appearance added an entirely new dimension to the trial. Wearing a simple but neatly pressed suit, he carried himself with the calm confidence of someone who had prepared thoroughly for this moment. As he took the witness stand, he looked directly at the judge, then at the prosecution, and finally at Simon Ekpa, who was seated quietly beside his lawyers. The testimony began with a clear statement. He said that Simon Ekpa is not the man that the prosecution has tried to portray. He described Simon Ekpa as a peace-loving individual, someone who has dedicated himself not to violence or terror, but to advocacy, dialogue, and support for human rights. He recalled that Simon Ekpa had been honored with a Peace Ambassador Award in Helsinki in the year 2023. He shared how Simon Ekpa had supported philanthropic efforts, including donations to community hospitals, scholarships for students from immigrant families, and free legal seminars on immigrant rights in Finland. He emphasized that Simon Ekpa is not only respected in the Nigerian diaspora community, but is also seen as a law-abiding citizen in Finland, known for his strong opinions but peaceful methods. The prosecution, not willing to let this testimony pass unchallenged, rose with sharpness in their voice. The prosecuting lawyer began a cross-examination that was intense from the first question. The lawyer attempted to corner the American witness, asking if the Biafra Republic government in exile had ever used funds raised from supporters to purchase weapons or support militant activities. The witness responded calmly, stating that the funds were always used transparently and that all fundraising activities were documented. He pointed out that as a citizen of the United States of America, he would never be involved in or support any illegal arms dealings. He even invited the court to request documentation, emails, and public records from both the Biafra Republic government in exile and American banking institutions if necessary. The prosecutor pressed harder, trying to catch the witness off guard. He presented vague documents, referred to anonymous tips, and hinted at suspicious transfers without providing solid names or evidence. The witness remained steady. At one point, he asked the prosecutor to clarify what he meant by supporting insurgency and whether peaceful agitation for self-determination qualifies as terrorism in Finland or the United States of America. The courtroom paused again. His voice, though soft, carried the echo of a larger question, one that courts in Europe have faced before when dealing with matters of foreign political struggles and how to classify them. Simon Ekpa sat quietly throughout, his expression unreadable, but his body language suggested a deep attentiveness to every word spoken. For the first time in many days, the narrative was being shaped not by accusation, but by personal testimony in his favor. The judge, who had remained neutral throughout, asked a few questions of his own. He inquired about the American witness's connection to Simon Ekpa and how long they had known each other. The witness replied that their friendship began during joint activism seminars in Helsinki several years ago, and that they had worked together on numerous peaceful civic programs, especially involving African immigrants in the Nordic region. As the cross-examination wound down, the prosecutor appeared increasingly frustrated. His attempts to shake the witness's composure failed, and instead, each answer from the American witness seemed to strengthen the defense's case. The prosecutor accused the witness of being evasive, but the judge disagreed, saying that the questions had often been vague and accusatory, and the witness had answered with clarity and patience. Simon Ekpa's lawyer then took the opportunity to address the court. With deliberate calmness, he said that this trial was becoming less about fact and more about fear. He accused the prosecution of attempting to intimidate witnesses instead of building a solid case based on verifiable evidence. He repeated that the burden of proof lies with the prosecution, and that so far their evidence had been shaky, inconsistent, and undermined by the admissions of their own key witness. Before leaving the stand, the American witness gave a final statement. He said that history will not look kindly on governments or institutions that try to suppress the voices of those who speak for justice. He said that Simon Ekpa, for all his fiery speeches and controversial opinions, remains someone who believes in law, order, and peaceful change. He warned that attempting to criminalize political activism without proof not only weakens the justice system, but also risks turning the court into a tool of silencing inconvenient truths. His words did not go unnoticed. Journalists scribbled, camera shutters clicked discreetly, and in the corner of the room, a few observers nodded in agreement. As the session ended for the day, a strange silence filled the air. The judge gathered his notes, and the lawyers began quietly collecting their papers. Simon Ekpa looked briefly at his legal team, exchanged a few words, and then stood up, prepared to be led back under legal supervision until the next court date. Outside the courtroom, reporters waited to capture reactions. The identity of the American citizen who testified remained partially withheld from public records, possibly for security reasons, but it was clear that his presence had left a significant impact on the direction of the trial. The people who had gathered outside the court earlier in the morning, including both Finnish locals and members of the Nigerian community in Europe, began to talk among themselves. Some supported Seaman Ekpa strongly, holding banners that read, "Self-determination is not terrorism." Others remained skeptical, wary of the complicated legacy of the Biafra struggle and its implications for Nigeria's fragile unity. But for many who had watched or heard about what happened inside that courtroom, the focus had shifted. This was no longer just a trial about one man's alleged actions. It had become a broader conversation about the right to political expression, the dangers of incomplete evidence, and the power of international voices in local courts. In the days that followed, Finnish newspapers began publishing detailed analyses of the trial. Headlines pointed to the credibility crisis in the prosecution's camp. Editorials debated whether the Finnish legal system was prepared to handle a case of this international and politically sensitive nature. Some questioned why Finnish prosecutors had agreed to take up such a case in the first place, given the complexity of Biafran politics. Others argued that Finland, as a country committed to the rule of law, must ensure that justice is not only done, but seen to be done, especially when international observers are watching closely. The next court session is scheduled for the second week of June, and expectations are high. Seaman Ekpa's defense team has indicated that they will call more witnesses, including one from a European human rights organization and another from Nigeria's southeastern region, who is expected to testify about local humanitarian projects funded by Seaman Ekpa. Whether these future testimonies will strengthen the defense further or give the prosecution a chance to regain its footing remains to be seen. But one thing is clear. The trial of Seaman Ekpa in Finland is no longer just about him. It is now about truth, about justice, and about the silent power that a single voice can have when spoken with courage, conviction, and calm clarity under oath. As the sun rose over Pihajoki on the 4th of June in the year 2025, the atmosphere surrounding the local courthouse remained thick with both anticipation and tension. The previous day's events had not just shaken the prosecution's narrative, but had set the tone for what had now become a high-profile international courtroom drama. What initially began as a criminal case against Seaman Ekpa, a dual Finnish-Nigerian citizen known for his controversial leadership role in the Biafra Republic government in exile, had evolved into something far more layered and symbolic. It had become a platform where global voices, historical grievances, legal principles, and human rights arguments were all converging into one singular story. Outside the courtroom on that morning, journalists from various international news agencies stood shoulder to shoulder. Some spoke Finnish, some English, and a few spoke Igbo, the native language of many southeastern Nigerians. They adjusted their microphones and lenses as they waited for signs of movement, hoping to catch brief interviews from legal representatives, human rights observers, or supporters of Seaman Ekpa. The Finnish police maintained a calm but firm perimeter, ensuring that tensions did not spill over into any form of disorder. Inside the courtroom, Seaman Ekpa was already seated, his posture upright, hands clasped lightly on the desk before him. His eyes moved steadily across the room, briefly settling on the same empty witness box that had witnessed the disintegration of the prosecution's star witness the day before. He was flanked on both sides by his defense lawyers, who appeared more confident than ever. Their strategy, which had seemed defensive in the earlier stages of the trial, was now beginning to look assertive and grounded in a powerful narrative that this entire case might be politically motivated and lacking solid forensic evidence. The judge entered shortly after, bringing the courtroom to its feet. He wore an expression of strict neutrality, but to those who had followed every minute of the trial, his eyes held a subtle weariness, perhaps the result of managing a trial that had rapidly spiraled into an intersection of politics, international law, and global civil rights. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.